Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only. It does not constitute legal, financial, or professional advice. Laws regarding domestic relations, marital dissolution, and attorney-client privilege vary significantly by jurisdiction and are subject to change over time. You should always consult with a licensed attorney in your specific state or locality before making any decisions related to your legal matters. Viewers are encouraged to conduct their own due diligence and recognize that historical trends and geographic data discussed here do not indicate specific potential outcomes for any individual case. Imagine two houses sitting side by side on a quiet suburban street. They share a zip code, a school district, and even a property line. But there is a nearly invisible boundary running right between them, a state border. In the first house, a couple decides to part ways. They find 30 specialized divorce attorneys within a 10-mile radius. The legal process is streamlined, and the market competition keeps costs within a predictable range. In the second house, just 50 feet away but across that state line, the nearest family law specialist is a 2-hour drive. The filing fees are triple, and the lack of attorney density means the few available practitioners can command astronomical rates with zero incentive for efficiency. This is the reality of the geographic lottery in the United States, where you choose to sign a marriage license, and more importantly, where you reside when that license is dissolved, can be the single most expensive geographic decision of your entire life. We are currently witnessing a massive, silent migration of legal talent that is reshaping the American judicial landscape. In this deep dive, we are going to uncover the hidden map of legal representation in America. We will analyze why some states have become oversaturated legal hubs while others have devolved into vast legal deserts. And we will explain exactly how these geographic concentrations dictate the speed, cost, and psychological toll of the American divorce process in 2026. This is a geographic study of divorce attorney distribution in the United States. To understand the distribution of divorce attorneys today, we have to look at the macroeconomic forces that govern where legal professionals set up shop. It is a common misconception that attorneys are distributed evenly according to the general population. In reality, the legal market follows the money with surgical precision. If we look at the historical trends of the last decade, we see a massive concentration of family law specialists in what researchers call high net worth enclaves. Areas like Fairfield County, Connecticut, the tech corridors of Northern California, and the suburban rings around Austin, Texas, show an attorney-to-client ratio that is nearly 8 times higher than the national average. But this isn't just about wealthy people needing more lawyers. It is about the complexity of the assets involved. In a geographic region dominated by stock options, intellectual property, and multi-state real estate holdings, a general practitioner won't suffice. This creates a gravitational pull for elite divorce attorneys, leading to a phenomenon known as professional clustering. Take, for example, the comparison between the New York City metropolitan area and the rural regions of the Midwest. In Manhattan, the density of matrimonial attorneys is so high that many firms have moved toward extreme specialization. You don't just find a divorce lawyer. You find a lawyer who specializes in high-conflict custody cases for international executives, or a lawyer who exclusively handles the valuation of private equity interests in divorce. This geographic density allows for a level of expertise that simply cannot exist in a low-density environment. However, this same density also creates a high-pressure economic environment. Because the overhead of running a firm in these hubs is so extreme, the minimum entry price for representation often exceeds the total net worth of an average household in a lower density state. This creates a paradoxical situation where the best geographic locations for legal choice are also the most financially inaccessible for the majority of the population. On the opposite end of the spectrum, we must examine the rise of the legal desert. According to recent demographic data, over 1,200 counties in the United States are currently categorized as having a severe shortage of legal professionals, with some counties having 0 resident attorneys at all. This geographic scarcity creates a ripple effect throughout the entire judicial system. In these areas, the few available attorneys are often generalists who may handle a criminal defense case in the morning and a property dispute in the afternoon, with a divorce filing squeezed in between. The lack of specialization in these geographic zones often leads to longer litigation times and a higher statistical likelihood of clerical errors or overlooked assets. For a resident in rural Nebraska or the Appalachian regions of Kentucky, the geographic distribution of attorneys isn't just a matter of convenience. It is a barrier to entry for the justice system itself. When you have to travel 3 counties over just to meet with counsel, the cost of distance becomes a primary factor in how, or if, a marriage is legally dissolved. Furthermore, we must look at the impact of state bar reciprocity and licensing laws on this distribution. Historically, the legal profession has been one of the most geographically sticky industries in America. Unlike a software engineer who can move from Seattle to Miami and keep the same job, an attorney is traditionally tethered to the state where they passed the bar exam. This has created artificial bottlenecks in the supply of legal talent. States with notoriously difficult bar exams or protectionist licensing rules often see a lower per capita distribution of attorneys, which in turn drives up the cost of service. We see this clearly when comparing the attorney distribution in California versus Florida. California's rigorous licensing and high cost of living have contributed to a concentration of attorneys in major coastal cities, leaving the Central Valley significantly underserved. Florida, conversely, has seen a massive influx of legal talent due to shifting population demographics and a legal environment that has historically been more conducive to firm expansion. Another critical factor in this geographic study is the influence of divorce tourism and how it has evolved into the modern era. In the mid-20th century, Reno, Nevada, was the divorce capital of the world because of its short residency requirements and favorable laws. While the Reno divorce is a relic of the past, the geographic strategy has not disappeared. It has simply become more sophisticated. Today, we see a trend of what sociologists call jurisdictional shopping. If a couple owns property in both New York and Florida, the decision of where to file can result in a difference of hundreds of thousands of dollars in alimony or asset division. This potential for varying outcomes has led to a strategic distribution of law firms along state borders. We see a high concentration of premium firms located in border cities like St. Louis, Kansas City, or the D.C. metropolitan area, where attorneys often hold dual licenses to capitalize on the geographic complexities of their clients' lives. As we move further into 2026, the rise of virtual litigation and remote legal services is beginning to challenge these traditional geographic boundaries. However, the physical distribution of attorneys still remains the primary driver of legal costs and outcomes. Even with Zoom hearings, the local knowledge of a specific county courthouse and the personal professional relationships between opposing counsel in a specific town remain invaluable assets that cannot be digitized. The geographic study of divorce attorney distribution is, at its core, a study of American inequality and the uneven application of the law. Over the next 9 parts of this series, we will break down the specific maps, the heat zones of legal fees, and the exact data points that reveal why your zip code might be the most important factor in your legal future. We are going to look at the efficiency gap in the South, the litigation premium of the Northeast, and the access crisis in the Mountain West. By the end of this masterclass, you will understand the American legal landscape not as a unified system, but as a complex, fragmented, and geographically driven market. To understand the efficiency gap in the American South, we have to look at the massive demographic shifts that have defined the early 2020s and accelerated into 2026. Historically, states like Georgia, North Carolina, and Florida have seen an unprecedented influx of residents from the Northeast and the West Coast. This migration has not just brought people, it has brought complex legal needs. Take the case of Marcus, a software consultant who moved from San Francisco to a suburb outside of Charlotte, North Carolina, in late 2024. By 2026, as Marcus navigated a complex domestic situation, he discovered the stark reality of geographic legal density. In Charlotte, the attorney-to-resident ratio has ballooned, creating a hyper-competitive market where firms are forced to innovate through technology to stay relevant. Here, Marcus found a lawyer using predictive analytics to estimate potential outcomes regarding asset division based on 3 years of local judicial rulings. This is the high-efficiency end of the spectrum. However, move just 60 miles outside of that metropolitan hub into the more rural counties of the South, and the efficiency collapses. In these zones, we see a historical trend of legal brain drain. Young, ambitious law school graduates are drawn to the higher billable hour potential of the cities, leaving vast swaths of the South with an aging population of general practitioners. In these rural areas, the legal process often moves at a glacial pace, not because the laws are more complex, but because the human infrastructure is spread too thin. A single family law judge might cover 3 counties, and the handful of available attorneys are often perpetually overbooked. This creates an efficiency gap where the time to reach a final decree can be 3 times longer in a rural county than in a neighboring urban center, despite the rural case being significantly less complex. This geographic discrepancy essentially places a time tax on residents based solely on their county of residence. Now, contrast this with the litigation premium of the Northeast. If the South is defined by its efficiency gaps, the Northeast is defined by its saturation and the resulting economic inflation. In the 2026 legal market of New York City or Boston, the sheer density of divorce attorneys is staggering. Within a 5-block radius of the New York County Supreme Court, there are more specialized matrimonial attorneys than in the entire state of Wyoming. You might think that high supply would drive prices down, but the Geographic study shows the exact opposite effect. In these hubs, the concentration of attorneys creates a specialized arms race. Firms invest heavily in premium office space, high-end branding, and specialized support staff including forensic accountants and private investigators. These overhead costs are passed directly to the consumer. Consider Sarah, a marketing executive in Manhattan. In 2026, her search for representation is not about finding an attorney, but about filtering through hundreds of options. The litigation premium in her geographic zone means that even a relatively straightforward case involves a level of financial vetting and paperwork that would be considered overkill in most other parts of the country. Historical trends in the Northeast suggest that as attorney density increases, the complexity of the litigation often increases as well. Attorneys in these high-density zones are more likely to pursue every possible legal avenue, resulting in cases that last longer and cost more than they might in a less saturated market. This is the paradox of choice in the legal geography. More options often lead to more expensive and prolonged conflict. Moving westward, we encounter the access crisis of the Mountain West, which is perhaps the most concerning geographic trend of 2026. In states like Montana, Wyoming, and Idaho, the map of attorney distribution looks like a few scattered islands in a vast ocean of nothingness. This is not just a matter of convenience. It is a structural failure of the legal market. In 2026, a resident in a remote part of Idaho might be 300 miles away from the nearest attorney who specializes in family law. This geographic isolation creates what we call legal shadow zones. In these zones, individuals often attempt to navigate the legal system pro se, meaning without any representation at all. Case studies from these regions show a significantly higher rate of lopsided settlements and procedural dismissals because the geographic barriers to professional help are simply too high to overcome. This access crisis has been exacerbated by the rise of the digital nomad. As more people move to the scenic mountain regions for the lifestyle, the demand for high-end legal services has increased, but the supply hasn't followed. The local attorneys who have been in these communities for decades are suddenly faced with cases involving multi-state property holdings and complex digital assets, often leading to a mismatch between client needs and local expertise. We are seeing a historical trend where residents in these regions are forced to import legal talent from major cities in other states, paying for travel time and premium rates, further inflating the cost of the geographic lottery. The Geographic study also reveals a fascinating trend in the Midwest, specifically in the Rust Belt cities like Detroit and Cleveland. Here, we see a stabilization of attorney distribution that serves as a middle ground between the Northeast saturation and the West scarcity. In these regions, the cost of living and the cost of legal services have remained more closely aligned with historical averages. However, even here, a new geographic divide is emerging based on the technological infrastructure of the local courts. In 2026, an attorney in a tech-forward county in Michigan can file documents and attend hearings entirely through integrated virtual portals, whereas an attorney in a neighboring county might still be required to hand-deliver physical paper copies. This creates a hidden geographic cost, the cost of technical obsolescence. When we look at the United States as a whole in 2026, the distribution of divorce attorneys is a perfect mirror of the nation's broader economic and social divisions. We have the hyper-efficient but expensive tech hubs, the saturated and litigious urban centers, the stable but aging middle market, and the vast underserved legal deserts. The Geographic study proves that your proximity to a cluster of legal professionals is one of the most significant predictors of your legal journey's duration and financial impact. It isn't just about what the law says, it is about who is available to argue it and how far you have to go to find them. The disparity is so great that some legal scholars in 2026 are calling for a national restructuring of how legal services are licensed, suggesting that the current state-based system is an archaic barrier that only serves to deepen these geographic inequalities. But until such a massive shift occurs, every individual must navigate the map they are given. We have discussed the broad strokes of the North, South, East, and West, but the most impactful geographic factor is often much smaller than a region or even a state. It is the invisible line of the county border. Why does filing for the exact same legal action in one county cost $4,000 while the county next door averages $12,000? The answer lies in the specific, localized clusters of attorney networks and the judicial culture of individual courthouses. In our next part, we are going to zoom in from the national level to the microscopic level. We will examine the secret map of county courthouses and reveal how attorney-judge relationships and local procedural quirks create local legal monopolies that can either save or drain your life savings. We will look at why some counties have become preferred destinations for filings, creating a hidden industry of domestic relations tourism that most people don't even know exists. If you thought the state-to-state differences were shocking, wait until you see what happens when we cross the county line. To understand the microscopic reality of the American legal landscape in 2026, we have to look at the invisible wall that exists the moment you cross a county line. While state laws provide the broad framework for marital dissolution, the day-to-day execution of those laws is governed by local rules of civil procedure. These are the specific, often granular requirements that dictate everything from the font size on a legal motion to the exact time of day a filing must be electronically submitted. In the geographic study of attorney distribution, these local rules act as a powerful barrier to entry, creating what economists call a knowledge moat. An attorney who is a powerhouse in one county may be completely neutralized in the neighboring county simply because they do not have the repetitive, daily experience with that specific courthouse's administrative quirks. This is why we see high-density clusters of law firms located within a 3-block radius of county courthouses. It is not just about convenience. It is about the geographic mastery of a specific micro-jurisdiction. Imagine a character named David. David lives in a rapidly growing metropolitan area in the Midwest where the city limits bleed across 3 different counties. In 2026, David is looking for representation. He discovers that if he files in the urban county where his office is located, the attorney distribution is massive, with over 500 specialized practitioners. However, the judicial backlog in that specific county is so severe that the historical trend suggests it takes an average of 18 months to reach a final hearing. If David can establish residency in the adjacent suburban county just 5 miles away, he enters a geographic zone where there are only 40 specialized attorneys, but the court system is fully modernized with AI-assisted docketing. In this suburban county, the timeline for a similar case drops to 6 months. This creates a geographic tension known as the venue race. Attorneys in these border zones often spend the initial weeks of a case strategically analyzing which county offers the most efficient geographic path for their client. This isn't just paperwork. It is a high-stakes geographic calculation that can save or cost a client tens of thousands of dollars in billable hours spent waiting for court dates. This leads us to the concept of the local legal monopoly. In mid-sized and rural counties across the United States, we often see a distribution pattern where 3 or 4 law firms handle nearly 80% of the domestic relations cases. In these geographic pockets, a unique ecosystem develops. The attorneys, the judges, and the court clerks have worked together for decades. They know each other's temperaments, preferred arguments, and even their personal schedules. While this may sound efficient, it creates a formidable challenge for any outside counsel. If a resident in one of these counties decides to hire a high-priced attorney from a major city 2 hours away, they are often surprised to find that their expensive representation is at a distinct disadvantage. The local attorney knows that Judge Miller in County X has a historical trend of being particularly conservative regarding the valuation of small businesses, whereas the outside attorney might rely on a standardized statewide model that simply does not resonate in that specific geographic culture. The geographic distribution of talent is thus tethered to the geographic distribution of judicial temperament. Furthermore, we must examine the physical economics of the Golden Mile. This is the term used in the legal industry for the high-rent district immediately surrounding a county courthouse. In 2026, despite the massive shift toward remote work, the price per square foot for law offices in these zones remains at an all-time high. Why? Because geographic proximity to the courthouse allows a firm to minimize non-billable travel time. If an attorney has 5 cases on the docket in one morning, being able to walk to the courthouse in 3 minutes versus driving 30 minutes through traffic represents a massive gain in professional efficiency. This geographic clustering, however, creates an economic filter. Only firms with a high volume of cases can afford the overhead of the Golden Mile. This leads to a distribution where the most experienced and specialized attorneys are physically bunched together, while newer or more generalist practitioners are pushed to the geographic periphery of the county. For the consumer, this means the quality of representation is often physically visible. The closer the office is to the courthouse steps, the more likely the firm is to have a dominant market share in that specific jurisdiction. In 2026, we are also seeing the rise of what researchers call domestic relations tourism at the county level. This occurs when individuals strategically utilize geographic loopholes to file in counties known for specific procedural advantages. For example, some counties in states like Texas or Florida have become known as fast-track zones due to their local administrative orders. This has led to an artificial spike in attorney density in these specific counties, far exceeding what the local population would normally support. Law firms are actually opening satellite offices in these specific high-efficiency counties just to capitalize on the influx of out-of-county filings. This geographic opportunism is reshaping the legal economy, turning previously quiet suburban courthouses into high-traffic hubs for domestic litigation. Another critical data point in our geographic study is the filing fee discrepancy. While you might assume a state has a uniform fee for filing a divorce, the reality is a patchwork of geographic surcharges. In 2026, filing for divorce in a high-density urban county might involve a base fee of $400, plus a mandatory $200 technology surcharge, and a $100 library fee. Cross the county line into a rural district, and the total cost might be a flat $150. Over the course of a long litigation process, these geographic variances in court costs, service of process fees, and mandatory mediation charges can add up to thousands of dollars in difference. Attorneys who practice across multiple counties must maintain complex spreadsheets just to track these geographic financial shifts for their clients. The geographic study of attorney distribution also reveals a widening tech divide in 2026. We are currently seeing a historical trend where attorney talent is migrating toward counties that have invested in integrated electronic evidence systems. In these high-tech geographic zones, an attorney can upload video depositions and financial spreadsheets directly to the judge's bench in real time. This attracts a specific caliber of attorney who specializes in complex, data-heavy cases. Conversely, counties that have lagged behind technologically are seeing a stagnation in attorney growth. This creates a geographic feedback loop. The most talented attorneys move to the most efficient counties, which then receive more funding and further improve their technology, while the underserved counties continue to lose their best legal minds to the neighboring jurisdictions. By analyzing the United States at the county level, we see that the legal system is not a monolith, but a collection of thousands of tiny, independent markets. Your geographic location within a state is often more important than the state line itself. The attorney you hire isn't just representing you. They are navigating a specific geographic maze that they have spent years, or even decades, learning to master. But there is another layer to this map that we haven't touched on yet. Beyond the courthouse and the local rules, there is the hidden factor of the regional economic pulse. Why do certain regions of the U.S. see a surge in specialized attorneys during economic downturns, while others see a mass exodus? In our next part, we are going to explore the economic weather map of the legal profession. We will look at how regional shifts in the housing market and the tech sector directly influence where the most aggressive attorneys set up their war rooms. We will also dive into the controversial practice of zip code premium pricing, where the exact same legal service is priced differently based on the perceived wealth of a specific neighborhood. We're moving from the courthouse to the boardroom to see how the economy dictates the geography of conflict. The economic weather map of the legal profession in 2026 reveals a stark reality. Divorce attorneys do not just follow people, they follow the specific types of wealth those people generate. To understand the geography of conflict, we must look at the concept of legal colonization. This occurs when a regional economy shifts, perhaps due to a new corporate headquarters or a sudden surge in property values, and the legal landscape transforms almost overnight to capture that new market. In 2026, we are seeing this most clearly in the secondary tech hubs of the United States, places like Salt Lake City, Utah, and Columbus, Ohio. These are cities that were historically served by stable, mid-priced general practitioners. But as the local economy shifted toward high-salary tech positions and complex equity compensation, the attorney distribution map underwent a radical redesign. Imagine a professional named James living in a suburb of Columbus in early 2026. James has been with a successful startup for 6 years. and his compensation package is heavily weighted with restricted stock units and performance-based bonuses. When James enters the legal market, he finds that the geographic distribution of attorneys has split into two distinct tiers. In the city center, a new breed of quant attorney has emerged. These are firms that have specifically moved their offices into high-end developments within walking distance of the new tech campuses. These attorneys don't just understand family law. They are essentially financial analysts with law degrees. They have built their entire practice around the valuation of unvested equity and the tax implications of 2026-era digital assets. In this scenario, James is facing zip code premium pricing. The firms located in the high-rent districts near the tech corridor charge a premium that is often 40 to 50% higher than firms just 10 miles away in the more traditional residential suburbs. This isn't just about the attorney's skill, it is about the geography of overhead. To maintain a presence in the neighborhood where James works, the firm must pay exorbitant commercial lease rates. This creates a feedback loop where the cost of the legal service is tethered to the perceived wealth of the immediate neighborhood. Historical trends show that as median household incomes in a specific zip code rise, the hourly rates of the attorneys within that same zip code rise disproportionately. It is a geographic tax on proximity. But why would James pay this zip code premium? The answer lies in the specialized knowledge of the local economic pulse. An attorney in a lower-cost geographic zone might be excellent at standard asset division, but they may lack the specific experience required to navigate the hyper-local corporate culture of James's employer. The high-priced attorney in the tech corridor likely represents 10 other people at the same company. They already have the plan documents for the company's 401k and stock programs on file. They know the historical trends of how that specific company handles employee benefits during domestic disputes. This geographic concentration of specific corporate knowledge creates a localized monopoly. James isn't just paying for a lawyer. He is paying for access to a repository of geographic-specific financial intelligence. Now, let's look at the real estate magnet effect, which is currently reshaping the attorney distribution in the Sun Belt. In 2026, Florida and Arizona are seeing a massive concentration of matrimonial attorneys who specialize exclusively in high-value real estate disputes. This is a direct response to the volatile housing market of the last few years. In a city like Miami, the distribution of attorneys is heavily weighted toward the waterfront districts. These firms have established what they call war rooms, offices equipped with advanced geographic information systems that allow them to track real estate trends in real time. If a couple owns a portfolio of short-term rental properties, they need an attorney who understands the specific zoning laws and local tax assessments of that particular coastal stretch. Consider a case study from the 2026 Miami market. A character named Elena is navigating a situation involving multiple high-value properties across 2 counties. She finds that the attorneys located in the heart of the financial district have built strategic alliances with local real estate appraisers and forensic accountants who operate in that same 3-block radius. This is the geography of synergy. Because these professionals are physically co-located, they can move with a speed that is impossible for a rural or suburban firm. However, the cost of this synergy is reflected in the retainer. Elena is informed that the initial cost just to open her file in this geographic hub is nearly double what it would be in the inland suburbs. The legal market in 2026 has effectively segmented the population based on their address, with the most aggressive and specialized talent clustering in the zones of highest economic activity. This leads to a phenomenon we call the Rust Belt paradox. In cities like Detroit or Pittsburgh, which have seen a significant economic rebirth by 2026, the attorney distribution is remarkably different. Instead of the hyper-specialized quant attorneys of the tech hubs, these regions have seen a resurgence of the industrial matrimonial specialist. These are attorneys who have deep geographic roots in the region and specialize in the division of traditional pensions, union benefits, and multi-generational family businesses. While the hourly rates in these geographic zones have remained more stable than in the coastal hubs, the scarcity of younger attorneys entering these specialized fields has created a different kind of pressure. In 2026, the historical trend in the Rust Belt shows that the most experienced attorneys are often booked months in advance, creating a geographic bottleneck that has nothing to do with money and everything to do with the aging demographics of the local bar association. We must also consider the impact of the regional economic downturn. In 2026, as the transition to green energy accelerates, regions that were historically dependent on oil and gas, like parts of western Texas or the Gulf Coast, are seeing a mass exodus of legal talent. As the local economy cools, The high-end divorce attorneys who once thrived on complex mineral rights cases are relocating to the growing tech and renewable energy hubs. This creates a legal vacuum in the vacated regions. The people left behind find themselves in a geographic zone where the available legal talent is diminishing, leading to higher costs for the few remaining practitioners who now face zero local competition. This is the economic weather map in action. Legal talent flows like water toward the areas of highest financial pressure, leaving the dry regions with a lack of adequate representation. Step by step, the legal industry in 2026 has become a mirror of the American economy. First, an economic shift occurs in a specific geographic region. Second, specialized legal talent migrates to that region to capture the new market. Third, the cost of living and commercial rent in that region drive up the cost of legal services. Fourth, a localized knowledge moat is built around the specific assets of that region's dominant industry. And finally, a tiered system of justice is established based on zip code and neighborhood wealth. As we move through 2026, the map of attorney distribution is more than just a list of office addresses. It is a heat map of American prosperity and conflict. But there is a factor that is beginning to disrupt this entire economic geography, something that is making the physical location of an office less relevant while simultaneously making the geographic location of the client more dangerous. In our next part, we are going to dive into the digital border war. We will explore how state line jumping and the rise of the ghost attorney are challenging the very foundations of geographic jurisdiction. We will look at the rise of the multi-state megafirm and how they are using data centers to compete with the local golden mile attorneys. What happens when the most powerful attorney in your county doesn't even live in your state? The answer will change everything you thought you knew about the geographic lottery of the American legal system. The digital border war is not fought with artillery or infantry, but with algorithms, high-speed bandwidth, and the strategic deployment of search engine optimization. In the legal landscape of 2026, the physical office is no longer the primary landmark for the distribution of attorney talent. We have entered the era of the digital shell office, a phenomenon that has fundamentally disrupted the geographic lottery. Historically, if you lived in a small town, your options were limited to the 3 or 4 practitioners with signs on Main Street. Today, a resident in a rural county in Iowa can open their laptop and be met with a barrage of advertisements for high-powered firms headquartered in Chicago or Des Moines. These firms may not have a single physical desk in that rural county, but they have established a dominant digital presence that makes them appear as local as the town sheriff. Imagine a character named John, a mid-level manager living in a quiet community in rural Iowa in 2026. John assumes that by searching for a divorce attorney near me, he will be connected with someone he might run into at the local grocery store. Instead, the top 3 results are multi-state megafirms. These organizations have essentially become the big box retailers of the legal world. They utilize massive data centers to monitor filing trends across thousands of counties simultaneously. When their data indicates an uptick in domestic filings in John's specific zip code, their advertising budget automatically shifts to saturate his social media feeds and search results. This is the first step in the digital border war. The geographic displacement of attention. John is no longer choosing from a local pool of talent. He is being recruited by a national infrastructure that treats his county as a mere coordinate on a growth chart. This leads us to the rise of the ghost attorney. In 2026, the legal industry has embraced unbundled legal services to an extent never seen in previous historical trends. A ghost attorney is a highly specialized practitioner who provides the intellectual heavy lifting, drafting complex motions, analyzing financial disclosures, and formulating strategy from a high-density legal hub like New York or Los Angeles, while a local proxy handles the physical appearances in the rural courthouse. This allows the client to access elite-level expertise that simply does not exist in their local geographic distribution. However, it creates a bizarre jurisdictional friction. The person writing the legal arguments may have never set foot in the state where the case is being heard. They are operating through a local attorney of record, who acts as the geographic anchor for the filing. This model has allowed megafirms to colonize underserved geographic zones without the overhead of physical expansion, effectively siphoning legal fees out of local economies and into major financial centers. The multi-state megafirm utilizes a strategy known as lead generation arbitrage. In 2026, the cost of acquiring a client in a saturated market like Manhattan might be $5,000 in advertising spend. However, in a less competitive geographic zone like Eastern Tennessee, that same client might only cost $500 to acquire. These megafirms use their massive capital to outbid local attorneys for digital real estate in these cheaper geographic zones. Once the client is signed, the firm uses its centralized tech platform to manage the case from a distance. For the local attorney in Tennessee, this is a devastating trend. They find themselves unable to compete with the marketing budgets of firms that aren't even physically present in their community. The result is a geographic consolidation of power, where a handful of massive entities are beginning to control the distribution of legal services across entire regions of the United States. We must also examine the impact of state line jumping in the age of remote work. In 2026, the traditional residency requirements for filing for divorce have become a major point of geographic strategy. Consider a case study involving a couple where one spouse works remotely for a company in Austin, Texas, but spends 6 months of the year in a rental property in Colorado. The distribution of attorneys in Austin is dense, and the laws regarding community property are well established. In Colorado, the legal landscape and the attorney-to-client ratio are different, and the equitable distribution model applies. In 2026, we are seeing a historical trend of jurisdictional maneuvering where individuals use their digital nomad status to jump across state lines just long enough to establish residency in a geography that offers a more favorable potential outcome for their specific financial situation. This has turned state borders into tactical boundaries that attorneys must navigate with extreme precision. This geographic blurring is further complicated by the move toward universal bar licensing. By 2026, several regional compacts have emerged that allow attorneys to practice across state lines within specific geographic blocks without needing to take multiple bar exams. This has accelerated the migration of legal talent. An attorney based in Charlotte, North Carolina, can now seamlessly handle cases in South Carolina and Virginia. This creates a regional legal powerhouse effect. Instead of 50 separate state markets, we are seeing the emergence of geographic legal zones. The Southeast Zone, the Great Lakes Zone, and the Pacific Northwest Zone are becoming unified markets where the most successful firms are those that can project power across multiple state lines simultaneously. But there is a significant risk to this digital expansion: the loss of the local judicial pulse. As we discussed in previous parts, every county courthouse has its own unique culture. A ghost attorney in a high-rise in Chicago might write a brilliant, data-driven motion for a case in a rural Iowa county, but they may completely miss the fact that the local judge has a long-standing historical trend of rejecting that specific type of technical argument. The digital border war offers efficiency and expertise, but it often sacrifices the nuanced, geographic-specific intelligence that only comes from physically standing in the same courtroom year after year. This has created a two-tier geographic market in 2026. On one hand, you have the high-tech, remote-heavy megafirms that offer standardized, efficient processing. On the other, you have the boutique local firms that market themselves on their geographic intimacy and their deep roots in the local community. Step by step, the process of geographic colonization by digital firms follows a predictable pattern. First, they identify an underserved or low-competition geographic zone through data analysis. Second, they deploy a targeted SEO and social media campaign to capture the local search volume. Third, they establish a partnership with a local attorney of record to satisfy jurisdictional requirements. Fourth, they move the substantive legal work to a centralized, lower-cost processing center. Finally, they use their scale to offer pricing structures that local firms cannot match. This cycle is currently hollowing out the middle class of the legal profession in rural and suburban America. As the physical and digital maps of the American legal system continue to merge, the geographic lottery has become more complex than ever. It is no longer just about where you are. It is about where your attorney's server is located and which state's licensing compact they are utilizing. The digital wall has fallen, but in its place, a new set of geographic traps is emerging. These traps are not based on distance, but on the hidden structures of the law itself, specifically, how the law handles the most precious and contentious of all geographic assets: the children. In our next part, we are going to dive into the custody corridor. We will explore how the geographic distribution of attorneys is being reshaped by the rise of multi-state co-parenting and the terrifying complexity of the interstate kidnapping statutes. We will look at why certain states have become safe havens for specific types of custody arrangements and how attorneys are using geographic positioning to win the battle for the home base. The map of the United States is about to look very different when we analyze it through the lens of parental rights and the long-distance relocation laws of 2026. The custody corridor is a term that defines the high-stakes geographic narrowness where parental rights are litigated across state lines. In the legal landscape of 2026, we have seen a massive increase in multi-state families, driven by the remote work revolution of the early 2020s that has now fully matured into a nomadic professional class. This geographic shift has created a specialized niche for attorneys who master the Uniform Child Custody Jurisdiction and Enforcement Act, commonly known as the UCCJEA. This act is the bedrock of custody geography, adopted by 49 states, the District of Columbia, Guam, and the U.S. Virgin Islands. It was designed to prevent the historical trend of parental kidnapping, where a parent would move a child to a different state to find a more favorable judge. However, in 2026, the UCCJEA has become a tactical map that attorneys use to plant a flag for what is known as home state jurisdiction. To understand how this works in practice, imagine a character named Chloe. It is 2026 and Chloe has been living in Seattle, Washington, with her 8-year-old son for the last 5 years. Her career in biotechnology is thriving, but she receives a life-changing job offer in Austin, Texas. Chloe wants to move, but her son's father, who also lives in Seattle, refuses to consent to the relocation. This is where the geographic study of attorney distribution becomes critical. In Seattle, there is a high density of relocation specialists, attorneys who do nothing but litigate move-away cases. These professionals understand that under the UCCJA, Washington is currently the child's home state because he has lived there for at least 6 consecutive months. If Chloe moves to Texas without a court order, she risks being caught in the gears of the Parental Kidnapping Prevention Act, a federal law that works in tandem with state statutes to ensure that one state respects the custody determinations of another. The attorney distribution in this scenario is lopsided. Chloe needs an attorney in Seattle to file the initial petition for relocation, but she also needs an attorney in Austin to scout the local judicial landscape. This creates a geographic double expense. Historical trends in move-away cases show that the parent seeking to relocate often faces a higher burden of proof, needing to demonstrate that the move is in the best interests of the child, rather than just a career advancement for the parent. The 2026 data shows that certain states have become safe havens for specific custody models. For example, states like Arizona and Florida have historical trends of leaning toward a 50-50 shared parenting time model as a default starting point. Conversely, other jurisdictions maintain a more traditional primary caregiver focus. This creates a geographic incentive for parents to fight for jurisdiction in the state that aligns with their desired outcome. Attorneys in border cities such as Vancouver, Washington, and Portland, Oregon, are among the most geographically sophisticated in the country. They must be licensed in both states because a move of just 10 miles across the Columbia River can completely change the legal standards for child support, custody, and the right to relocate. In these border zones, we see the highest concentration of jurisdictional warfare specialists. These attorneys utilize a step-by-step process to secure home state status. Step 1 is the 6-month residency check. Step 2 is the significant connection test, which is used if no state qualifies as the home state. Step 3 is the emergency jurisdiction filing, often used in high-conflict cases where safety is a concern. The distribution of these attorneys is not random. They cluster in counties that sit on the edge of state lines, where the population is most transient and the potential for interstate conflict is highest. Consider the 100-mile rule, a geographic constraint found in the statutes of several states, including Michigan. This rule states that a parent cannot move a child more than 100 miles from their current residence without court approval, even if they stay within the same state. This creates a geographic bubble around the child's home. In 2026, we see attorneys in the Midwest specializing specifically in the 100-mile litigation. They use geographic mapping software to plot the exact distance between two residences, often arguing over a matter of a few hundred feet. If a parent moves 99 miles away, they might be safe. At 101 miles, they are in violation of a standing order. This precision requires a level of geographic expertise that general practitioners simply do not possess. The role of the guardian ad litem also varies geographically. In 2026, some counties have a massive distribution of these court-appointed advocates, while in others, they are almost non-existent. A guardian ad litem is a professional, often an attorney, appointed to represent the child's best interests. In high-density urban areas, the guardian ad litem is often part of a large, state-funded agency. In rural counties, the court might appoint a local attorney who has a general practice. This geographic variance significantly impacts the outcome of custody cases. A professional investigator in a major city might conduct a deep dive into the school systems and extracurricular activities of both the current and the proposed new location, whereas a rural appointee might rely more heavily on local character witnesses. Furthermore, we must look at the impact of geofencing and digital surveillance in 2026 custody orders. Modern attorneys are increasingly writing geographic restrictions into custody decrees that utilize the GPS data from a child's phone or a parent's vehicle. These orders might stipulate that a parent cannot take the child outside of a specific county or set of counties without written notice. The distribution of attorneys who are tech-savvy enough to draft and enforce these digital geographic orders is concentrated in the major tech hubs. This creates another layer of the geographic lottery. A parent in a tech-forward county has access to more sophisticated legal protections than a parent in a county where the legal culture is still based on paper and trust. The financial burden of the custody corridor is immense. Case studies from 2026 show that interstate custody battles are among the most expensive forms of litigation in the American legal system. Beyond the attorney fees in 2 different states, there are the costs of travel for hearings, the cost of flying children back and forth for parenting time, and the cost of expert witnesses who must testify about the comparative quality of life in 2 different geographic regions. The geographic distribution of specialized travel coordinators for legal cases has even become a sub-industry in cities like Atlanta and Chicago, which serve as major transit hubs for these bicoastal families. As we analyze the map of the United States through this lens, we see that the legal system has built a series of walls and gates designed to keep children in place. The attorneys who navigate these gates are the masters of the interstate compacts. They understand that a case is not won just on the facts, but on the coordinates. If you can control where the case is heard, you can often control the potential outcome of the entire dispute. This geographic dominance is the ultimate goal of the jurisdictional specialist. But while the battle for the child's home base is fought on the ground, another even more complex geographic war is being fought in the cloud and the ledger. How does the American legal system handle a divorce when the primary assets are not physical houses or cars, but decentralized digital currencies and international corporate structures? In our next part, we are going to explore the forensic frontier. We will look at the geographic distribution of attorneys who specialize in hunting for hidden assets across global boundaries. We will dive into the rise of the divorce bounty hunter and how the legal map of the U.S. is being redrawn by the search for offshore accounts and encrypted wealth. The journey from the local courthouse to the global financial shadow market begins now. The forensic frontier begins where the physical world ends and the digital ledger takes over. In the geographic study of attorney distribution, we must recognize that as we enter 2026, the traditional assets of a marriage, the family home, the minivan, the joint savings account, have been surpassed in complexity by decentralized finance, offshore corporate structures, and intellectual property portfolios. This has necessitated a radical shift in where specialized legal talent clusters. We are seeing a historical trend where the most aggressive asset hunters are no longer found in general practice firms, but are concentrated in hyper-specialized boutique offices located in global financial hubs. These are the divorce bounty hunters of the 2020s, and their distribution map is a perfect overlay of the world's most secretive financial corridors. To see this in action, imagine a character named Robert. Robert is a high-level executive at a private equity firm in Greenwich, Connecticut, but his primary residence is in Manhattan. Over the last decade, Robert has systematically diversified his wealth. He doesn't just have a 401k. He has a series of limited liability companies registered in Delaware, a minority stake in a luxury resort in Belize, and a significant holding in a private blockchain-based investment fund. When Robert's spouse, Linda, decides to file for divorce in 2026, the geographic distribution of attorneys becomes her most critical weapon. If Linda hires a high-quality, local family law attorney in a typical suburb, that attorney may be overwhelmed by the sheer geographic sprawl of Robert's assets. To level the playing field, Linda must look toward the forensic matrimonial specialists clustered in the financial districts of New York City or London. These specialists operate differently than traditional lawyers. Their offices are essentially private intelligence hubs. In 2026, a top-tier forensic attorney in a major hub like Miami or Los Angeles doesn't just have paralegals. They have staff forensic accountants who are certified in blockchain analytics and private investigators who specialize in international corporate veils. This is the geography of the hunt. The reason these attorneys cluster in these specific cities is because of their proximity to the banking infrastructure and the regulatory bodies that govern global wealth. In Miami, for instance, we see an incredible density of attorneys who specialize in Latin American and Caribbean asset tracing. This isn't a coincidence. It is a geographic response to the historical trend of capital flight from South America into Florida real estate and offshore accounts. The step-by-step process of the forensic frontier is a masterclass in modern litigation. First, the attorney performs a lifestyle audit. This is a geographic comparison of reported income versus actual spending. If Robert claims a salary of $300,000 but spends 6 months of the year at a villa in the south of France that costs $50,000 a month to maintain, the forensic attorney uses geographic data, travel records, credit card processing locations, and social media geotags to prove the existence of undisclosed income streams. Second, they initiate digital forensic imaging. In 2026, this involves searching for encrypted apps or hidden digital wallets that may be holding decentralized assets. Third, they move to the jurisdictional subpoena phase. This is where the geographic expertise of the attorney is truly tested. A lawyer in a rural county may not know how to effectively serve a subpoena on a shell company registered in the Seychelles, but a specialist in the New York-London corridor does this every Tuesday. This leads us to the Delaware maze. Delaware is a tiny state with a massive geographic footprint in the legal world. Because of its favorable corporate laws, more than 60% of Fortune 500 companies are incorporated there. In 2026, attorneys in Wilmington, Delaware, have become the gatekeepers of the corporate divorce. They have developed a niche distribution pattern where they act as local counsel for high-net-worth divorces happening in other states. If Robert has funneled his marital assets into a series of Delaware-based LLCs, Linda's primary attorney in New York must collaborate with a Delaware specialist who understands the specific historical trends of the Delaware Court of Chancery. This geographic partnership is a requirement for any case involving complex corporate structures. Furthermore, we must examine the rise of the shadow map. This is the disconnect between where the money is earned and where it is hidden. In 2026, we are seeing a trend of autonomous wealth managers, AI-driven systems that automatically move assets between jurisdictions to maximize tax efficiency and minimize visibility. To combat this, a new breed of attorney has emerged in the tech corridors of San Francisco and Austin. These attorneys are often dual qualified in software engineering and law. They represent a new geographic cluster, the Silicon Valley Forensic. They don't just look for bank statements, they look for code. They look for smart contracts that are programmed to trigger asset transfers upon the filing of a divorce petition. The distribution of these tech legal hybrids is extremely narrow, creating a massive advantage for those who can afford their services. The economic barrier created by this geographic specialization is one of the most significant inequalities in the 2026 legal system. The cost of hiring a forensic team in a major hub can easily exceed $100,000 in initial retainers alone. This creates a situation where the geographic lottery is not just about where you live, but about whether you can afford to bridge the gap between your local courthouse and the global financial centers. Historical trends suggest that in nearly 40% of high-net-worth divorces, a significant portion of assets remains undiscovered because the spouse lacked the geographic access to specialized forensic talent. In 2026, the forensic frontier is also being shaped by the Foreign Account Tax Compliance Act and other international transparency initiatives. However, as the law becomes more transparent, the geography of hiding becomes more creative. We are seeing a shift toward tangible assets in unregulated jurisdictions, high-value art stored in free ports in Switzerland or Singapore, and mineral rights in emerging markets. The attorneys who can navigate these geographic anomalies are the most sought-after professionals in the country. Their distribution is a map of the world's elite wealth, and they serve as the ultimate check on the financial shadow market. As we move forward, the forensic hunt will only become more geographically complex. The physical office in a high-rise in Manhattan is just the front door to a global network of investigators, accountants, and local proxies. The geographic study of attorney distribution proves that in the battle for marital assets, the most powerful player is the one who can see the furthest across the map. We have looked at the children and we have looked at the cash, but there is one final piece of the geographic puzzle that dictates the long-term survival of both parties. It is the silent, ongoing transfer of wealth known as the alimony archipelago. Why does a 10-minute drive across a state bridge result in a lifetime of alimony in one direction and zero in the other? In our next part, we are going to dive into the alimony archipelago. We will look at the geographic distribution of the maintenance hawks, attorneys who specialize in the permanent wealth transfers dictated by state-specific formulas. We will analyze the alimony war rooms of the South and the lifetime support strongholds of the Northeast. The map of the United States is about to be divided into the payers and the receivers, and your geographic coordinates will determine which side of the line you stand on. The alimony archipelago is a fragmented landscape where the financial obligations of a failed marriage are dictated more by the soil beneath your feet than the length of your union. As we move through 2026, the geographic distribution of attorneys who specialize in maintenance, commonly known as alimony, has reached a point of extreme polarization. In the American legal market, we see a clear divide between the maintenance hawks, who cluster in states with generous long-term support statutes, and the restrictionist defenders, who dominate the legal landscape in states that have systematically gutted alimony rights over the last decade. This geographic divergence has created a situation where two individuals with identical incomes, identical marriage lengths, and identical assets can face vastly different potential outcomes simply because they live on opposite sides of a state line. To understand the intensity of the Northeast strongholds, imagine a character named Elizabeth. Elizabeth and her spouse have lived in a high-wealth suburb of New Jersey for 24 years. Her spouse is a senior executive in the pharmaceutical industry, while Elizabeth stepped away from a promising career in interior design to manage their household and support her spouse's professional ascent. In 2026, as they navigate a dissolution, Elizabeth enters one of the most alimony-friendly geographic zones in the nation. The attorney distribution in northern New Jersey and southern Connecticut is heavily weighted toward firms that market themselves specifically on their ability to secure open durational alimony. These firms are the maintenance hawks. They operate out of alimony war rooms, offices equipped with proprietary software designed to calculate the exact lifestyle maintenance required to keep a spouse in the station to which they became accustomed during the marriage. In this geographic zone, the legal culture is built on the philosophy of economic parity. The attorneys here utilize a step-by-step process that begins with a deep-dive lifestyle analysis. They don't just look at bank statements. They look at the geographic cost of maintaining a specific social standing. They calculate the annual cost of club memberships in the Hamptons, the projected tuition for private schools in New England, and the historical trends of luxury inflation. Because the laws in these states still allow for significant judicial discretion, the distribution of attorneys is dense with high-stakes litigators who know how to present a compelling narrative of sacrifice and contribution. The cost of representation in these strongholds is among the highest in the country, but the potential outcome, a lifetime of consistent support, justifies the premium for many clients. Now, contrast Elizabeth's situation with a character named Michael, who lives in Austin, Texas. Michael has been married for 15 years and earns a significant income in the tech sector. If Michael were in New Jersey, he might be facing a decade or more of high-value alimony payments. However, because he is in Texas, he is in one of the most alimony-restrictive geographic zones in the United States. In Texas, the law generally caps spousal maintenance at $5,000 per month or 20% of the payer's average monthly gross income, whichever is less, and usually limits the duration to a few years unless there are extreme circumstances like a disability. This legal reality fundamentally changes the attorney distribution in the South. You will find far fewer firms in Texas or Florida that lead with alimony as their primary marketing hook. Instead, the attorneys in these regions are specialists in asset division. They understand that since alimony is capped, the real battle is fought over the characterization of separate versus community property. The geographic study shows that in restrictionist states, the most successful attorneys are those who can find creative ways to front-load a settlement through property distribution to compensate for the lack of ongoing support. This is a historical trend where the geography of the law has forced the legal market to evolve. If you cannot get money through a monthly check, you must get it through the house, the stock options, or the retirement accounts. Between these two extremes lies the alimony archipelago's middle ground, states like Illinois or Colorado that utilize standardized formulas. In these geographic zones, the distribution of attorneys has shifted toward efficiency and automation. In 2026, a family law attorney in Denver uses a localized version of a maintenance calculator that takes the gross income of both parties and the duration of the marriage to spit out a suggested amount and length of support. This has led to a commoditization of alimony legal services. Because the potential outcomes are more predictable, the high-conflict alimony litigator is becoming a rarity in these formula-based states. Instead, we see a rise in mediation-heavy firms that focus on reaching a settlement that mirrors the state-mandated formula as quickly as possible. We must also examine the impact of the 2026 tax landscape on this geographic study. Historically, alimony was tax-deductible for the payer and taxable income for the receiver. When the federal tax laws changed, removing the deduction, the geographic impact was felt most heavily in high-tax states like New York and California. Attorneys in these regions had to completely rewrite their playbooks. In 2026, we see a massive concentration of tax-literate matrimonial attorneys in these states who specialize in tax-neutralizing alimony payments. They use geographic-specific tax strategies, such as structured settlements involving municipal bonds or complex insurance products, to replicate the financial benefits that were lost when the federal deduction disappeared. This is a level of sophistication that you rarely find in states with no income tax, like Nevada or Washington, further deepening the geographic divide in legal expertise. The geographic study also reveals a fascinating trend regarding cohabitation clauses. In 2026, attorneys in the Southeast, specifically in states like Georgia and North Carolina, have become the nation's leading experts in ending alimony obligations through geographic surveillance. Because these states often allow for the termination of alimony if the receiver cohabitates with a new partner, a sub-industry of alimony investigators has emerged. These professionals work hand-in-hand with law firms to track the geographic movements of ex-spouses. If a receiver is spending more than 4 nights a week at a new address, the maintenance hawks in these regions move in for the kill. This has created a defensive geographic culture where individuals receiving alimony are often advised by their attorneys to maintain strict geographic separation from new romantic interests to protect their support streams. Furthermore, we are seeing the rise of the reentry specialist in the Midwest. In states like Ohio and Michigan, where the economy has seen shifts in manufacturing and healthcare, there is a high distribution of attorneys who specialize in rehabilitative alimony. This is support specifically designed to pay for the education or training a spouse needs to re-enter the workforce. These attorneys have built networks with local universities and vocational schools to provide the court with concrete geographic-specific data on the cost and duration of retraining. This is a highly localized form of legal practice that reflects the regional economic needs of the middle of the country. The alimony archipelago proves that the American legal system does not believe in a single standard of fairness. Fairness is defined by the legislature of the state where you file. As we look at the map of the United States in 2026, we see a country divided into zones of lifelong obligation and zones of temporary assistance. The attorneys who navigate these waters are experts in the specific financial DNA of their regions. They know that a 10-minute drive across a bridge can represent a multi-million-dollar shift in lifetime wealth. But while alimony defines the ongoing relationship between former spouses, there is a document that attempts to override the entire geographic lottery before the marriage even begins. In our next part, we are going to explore the prenuptial pressure points. We will look at why certain states have become the go-to locations for drafting ironclad premarital agreements, and how the enforceability map of the U.S. is forcing couples to choose their wedding locations with the precision of a corporate merger. We will dive into the rise of the international prenup, and how attorneys are using geographic jurisdictional clauses to bypass state laws entirely. The battle to opt out of the geographic lottery begins now. The prenuptial agreement is the ultimate geographic pivot point. If the geographic lottery of American divorce is a game of chance, the premarital agreement is the proactive attempt to rig the board in your favor before the game even begins. In the legal landscape of 2026, the distribution of attorneys who specialize in these documents has become incredibly concentrated. We are no longer seeing these as simple add-ons to a general family law practice. Instead, we are seeing the rise of the prenuptial architect, a specialized legal professional who clusters in the highest-stakes geographic hubs of the United States. These architects do not just draft documents. They build jurisdictional fortresses designed to survive the diverse and often conflicting legal climates of 50 different states. To understand the intensity of this geographic specialization, we have to look at the enforceability map of the United States. In 2026, this map is divided primarily between states that have adopted the Uniform Premarital Agreement Act, or UPAA, and those that have not. The UPAA was designed to create a historical trend of consistency, ensuring that an agreement signed in Virginia would be just as valid in California. However, the geographic reality is far more fractured. Even within UPAA states, the local judicial interpretation of what constitutes a fair disclosure of assets varies wildly from county to county. This has created a demand for attorneys who possess a deep geographic intelligence regarding where an agreement is most likely to be upheld versus where it is most likely to be shredded by a skeptical judge. Imagine a character named Liam, a tech entrepreneur in Seattle, Washington, who is planning to marry Ava, a medical researcher in Boston, Massachusetts, in late 2026. Liam has significant holdings in a venture-backed startup, while Ava has a portfolio of inherited real estate in New England. Their life together will likely take them through multiple states as their careers evolve. In this scenario, the geographic distribution of their legal counsel is the first major hurdle. Historical trends show that for a prenuptial agreement to be considered robust in 2026, both parties must have independent counsel in the state where the agreement is signed. But what happens if they sign in Washington and move to Massachusetts 2 years later? This is where the choice of law clause becomes the central geographic battleground. A sophisticated attorney in 2026 will often advise Liam and Ava to include a clause stating that the laws of a specific state, perhaps a state with very strong enforcement historical trends like Texas or Florida, will govern the agreement regardless of where they eventually divorce. This creates a geographic anomaly. A couple living in a high-tax, alimony-friendly state like New York might find their entire financial future governed by the restrictive statutes of a state they haven't visited in a decade. The attorneys who specialize in these cross-border clauses are a rare breed, usually found in the high-rise offices of the multi-state megafirms we discussed in previous parts. The drafting heat map reveals that the highest fees for prenuptial agreements are currently found in the California-New York corridor. In California, the 2026 legal market is still reacting to the 7-day rule and the mandatory independent counsel requirements that have become the gold standard for enforceability. Attorneys in San Francisco and Los Angeles charge a significant premium because the liability associated with these documents is immense. A prenuptial agreement is, in many ways, a malpractice time bomb. If an attorney fails to follow a single procedural requirement in a specific geographic jurisdiction, the entire document can be invalidated 20 years later. This has led to a geographic scarcity of attorneys willing to draft these agreements for mid-market clients, as the risk-to-reward ratio is simply too high. In 2026, we are also witnessing the rise of the international prenup. As the professional class becomes more global, we see a historical trend of couples with assets in multiple countries and dual citizenships. This requires a level of geographic coordination that was once reserved for corporate mergers. An attorney in New York may need to coordinate with a solicitor in London and a notary in Paris to ensure that a single agreement is enforceable across 3 different continents. These international specialists cluster near major international airports and financial centers, creating a specialized legal archipelago that exists almost entirely outside the traditional state-based system. Step by step, the process of building a geographic fortress in 2026 follows a rigorous protocol. Step 1 is the geographic asset mapping. The attorney must identify not just what the assets are, but exactly where they are located. A house in France is governed by different marital property rules than a condo in Miami. Step 2 is the jurisdictional selection. The attorney analyzes the historical trends of various states to find the one that offers the most predictable potential outcomes for the client's specific asset profile. Step 3 is the dual counsel requirement. To prevent a later claim of duress or lack of understanding, both Liam and Ava must be represented by attorneys who are physically located in the jurisdiction where the contract is executed. Step 4 is the transparency audit, a meticulous, geographically documented disclosure of every single asset, account, and debt. But even with the most ironclad agreement, the geographic lottery still looms. In 2026, we are seeing a trend of what legal scholars call the unconscionability review. Some states allow a judge to throw out a prenuptial agreement if, at the time of the divorce, the enforcement of the agreement would leave one spouse in a position of extreme financial hardship. This is a highly subjective and geographically dependent standard. A judge in a wealthy county in Connecticut might have a very different definition of hardship than a judge in a rural county in Alabama. This geographic variance means that a prenup is never truly a finished product. It is a living document that must be geographically monitored as the couple moves throughout their lives. Furthermore, the 2026 legal market has seen the emergence of the postnuptial specialist. These are attorneys who specialize in agreements signed after the marriage has already begun, often triggered by a significant geographic move or a sudden change in financial status. For example, if Liam and Ava move from a community property state like Washington to an equitable distribution state like New York, their attorney might suggest a postnuptial agreement to clarify how their assets should be treated under the new geographic rules. However, The historical trends for the enforceability of postnuptial agreements are even more volatile than prenups, with some states viewing them with extreme skepticism. The Geographic study of attorney distribution proves that the prenuptial agreement is the primary tool used by the wealthy to opt out of the uncertainties of the state-based system. By choosing their own laws and their own jurisdiction, they are attempting to create a private legal system within the public one. But for the majority of the population, this level of geographic engineering remains out of reach due to the high cost of specialized counsel. This creates a two-tiered geographic reality: those who are governed by the default laws of their zip code, and those who have the resources to buy their way into a different jurisdiction. We have now analyzed the national landscape, the county-level monopolies, the digital border wars, the custody corridors, the forensic frontiers, and the alimony archipelagos. We have seen how the geography of the law dictates the economics of the family. But as we reach the conclusion of this masterclass, there is one final essential piece of the map. We need to synthesize all of this data into a single actionable strategy. In our final part, we are going to unveil the geographic endgame. We will provide the ultimate master map of the United States, a definitive ranking of the best and worst jurisdictions for every major factor we've discussed. We will look at the emerging trends that will define the rest of the 2020s and give you the step-by-step checklist for navigating the geographic lottery, whether you are planning a marriage or navigating its end. The complete picture of American legal geography is about to be revealed. The Geographic Endgame of the American legal system in 2026 is a study in radical decentralization. To navigate this final layer, we must synthesize everything we have covered: the county-level monopolies, the digital border wars, and the financial frontiers. We are now at the point where we can map the United States not by state lines, but by the potential outcomes dictated by three primary geographic factors: speed of resolution, cost of representation, and the predictability of asset division. By looking at the 2026 data, we can identify specific hubs that have become the gold standard for efficiency, as well as the zones that remain bogged down in historical legal friction. To understand the efficiency tier of 2026, we look at states like Utah and New Hampshire. These jurisdictions have become the unexpected leaders in geographic legal innovation. In Utah, the distribution of attorneys has shifted toward a model where nearly 70% of the process is handled through integrated digital portals. This has created a historical trend of cases being resolved in under 6 months for uncontested matters. The attorneys in these regions are not just legal experts, they are masters of the administrative workflow. Contrast this with the efficiency floor found in the urban centers of California and New York. In 2026, the Geographic study shows that despite having the highest density of attorneys in the world, these regions suffer from the most significant judicial backlogs. A case in Los Angeles County may take 4 times longer to reach a final decree than a similar case in a tech-forward county in the Mountain West. This creates a geographic penalty for those living in high-density urban zones. Now, let us look at the 2026 cost tier through the lens of a character named Derek. Derek is a project manager who has spent the last decade living in San Jose, California. As he evaluates his legal options in 2026, he discovers the geographic premium of Silicon Valley. In his immediate zip code, the retainer for a specialized matrimonial attorney starts at $25,000. This is the result of extreme professional clustering where the cost of doing business, office rent, staff salaries, and professional insurance is at a national peak. However, Derek discovers that if he utilizes the 2026 unbundled service model and hires a consultant from a lower-cost geographic zone like Sacramento, his initial costs drop by nearly 60%. This is the geographic arbitrage of 2026. Derek is essentially buying the same legal knowledge, but at a price point dictated by a different set of geographic overheads. The third tier is the outcome predictability map. In 2026, we see a clear historical trend where states with formulaic alimony and child support laws, such as Illinois and Massachusetts, provide the most geographic certainty. In these regions, the distribution of attorneys is centered on settlement and mediation, because the potential outcomes are so clearly defined by the state-mandated calculators. Conversely, in states that allow for high levels of judicial discretion, like South Carolina or Mississippi, the attorney distribution is dominated by high-stakes litigators. In these geographic zones, the lack of a formulaic outcome creates a market for aggressive representation. The legal geography here is a battleground where the specific temperament of a local judge is the most valuable piece of intelligence an attorney can possess. Step by step, The Geographic study reveals a final checklist for anyone navigating the 2026 landscape. The first step is the jurisdictional audit. This involves verifying the exact residency requirements of your current location and any location you have lived in for the last 12 months. In 2026, many people are surprised to find they are eligible to file in multiple jurisdictions, each with vastly different historical trends for asset division. The second step is the attorney density analysis. You must look beyond the first page of search results to see if your county is a legal desert or a saturated hub. A legal desert may offer lower costs but carries the risk of a generalist handling a complex case. A saturated hub offers expertise but carries the litigation premium. The third step in the checklist is the technological infrastructure check. In 2026, the efficiency of your legal journey is tied to the digital maturity of your local courthouse. You should investigate whether your county supports electronic filing, remote hearings, and AI-assisted docketing. If you are in a technologically obsolete county, your legal costs will inevitably be higher due to the manual labor required by your attorney. The fourth step is the local judicial review. This is where you analyze the historical trends of the specific judges in your county. In 2026, data scraping tools allow attorneys to see exactly how a judge has ruled on similar cases over the last 5 years. This geographic data is the ultimate shield against unpredictable outcomes. The final step is the multi-state strategy. If you or your spouse own property in different states, you must coordinate with attorneys in both geographic zones. In 2026, the most successful individuals are those who treat their domestic situation with the same geographic precision as a corporate relocation. They don't just hire a lawyer. They build a geographic legal team that spans the relevant jurisdictions. This is the reality of the 2026 legal market. The map is more important than the law itself. As we conclude this masterclass, it is clear that the United States legal system is a fragmented collection of geographic micromarkets. From the Alimony Archipelago to the forensic frontier, your coordinates dictate your costs, your timeline, and your eventual financial recovery. We have seen how the rise of the multi-state megafirm and the digital border war are challenging the traditional boundaries, but the physical location of the courthouse remains the ultimate anchor of the law. The geographic lottery is real, but it is not invisible. By studying the distribution of talent and the infrastructure of the courts, you can move from a position of geographic vulnerability to a position of informed strategy. But even as we map the physical and digital boundaries of 2026, a new shadow is falling over the legal landscape. We are starting to see the emergence of a system that goes beyond geography and into the realm of the algorithmic. What happens when the distribution of attorneys is no longer dictated by zip codes or state lines, but by the processing power of a server? In our next series, we will explore the rise of the algorithmic judge and the end of the human courthouse. We will look at the first counties in the U.S. that are experimenting with AI-driven dispute resolution, and how this is creating a new invisible map of justice. The Geographic study was just the beginning. The digital evolution of the American law is about to rewrite the rules entirely. For now, understand your map, know your coordinates, and remember that in the 2026 legal system, your location is your destiny.